Right, so we got a lot to cover, and we allocated 60 minutes to be respectful of your time. So I'm going to go fast, but hope to have some time for questions and answers at the end. I love my job. I have a job where I get to focus in on standard construction contracts. I should actually mention today that the views on today's webinar are my own, not my employer's. But I hope today to help you leverage the content of the standard construction contracts, which play such an important role in our industry in evolving best practices and industry norms, and what's fair for parties to contract with one another on construction projects. And the standard documents help lead the way to do that. And in the very recent history of really 2017, both the major standard form contracts have been comprehensively updated. So what I hope to do is go over those, both the AIA A201 as well as the Consensus Docs 200, and the major general conditions of both of those documents, with a mind for how are you going to take those changes and either use them whole cloth in one of the standard documents, or how are you going to incorporate those contracting practices in what you do every day, which may borrow or use those standard documents in whole cloth or as a reference point. So with that, I'm going to bounce around a bit from both the AIA and the Consensus Docs. And so let me start with the AIA documents. As you probably know, the AIA documents are the most used standard construction contract documents in the industry, except actually what I get reported at meetings is the most common standard document in the construction industry really is none of the above, right? Because a lot of times you're seeing quote-unquote original documents that are either so modified of standard documents or just made from scratch, or made from maybe people who aren't even construction attorneys but are really more real estate attorneys, or it's just a homegrown contract document. But those are, I could spend some time talking about the value of standard documents, but generally the standard documents provide the foundation which you're going to see most of your contracts. So the A201, I like to call it the AIA 201 because it's clearly from the perspective of the design professional community writing the documents. They make their documents updates every 10 years. So they don't make off-cycle changes based upon changes in the law and what have you. This is they've been around for over 100 years, and they have established a 10-year cycle over the past really 30 years that it's more routine on the sevens. And so this one is, let's compare it quickly to what was done in 2007. From my perspective, 2007 was a bigger change, was maybe more of a shift. In that update, you saw the Associated General Contractors and the subcontractors both not endorsing that document and going in other directions away from looking to the AIA documents as the industry standard documents that they sort of endorse. This time around, there were important changes, but the general overall feel from most associations and commenters is that it is not a major rewrite of the 2017. In fact, AIA has basically said that, except in the area of insurance. So that being said, I would say that the changes in 2017, they're somewhat significant. They're certainly not inconsequential. And one of the things you really need to keep in mind is while the AIA documents have been around for over 100 years and have gone through the courts and have a lot of case law associated with them, which has got some pros and cons to that, is that when there are changes, some of this is you just don't know how it's going to be interpreted if it goes to court and litigated with some of the changes that we're going to talk about today. Now, I'm going to give you a little bit of the AGC perspective because I have two hats. I'm the Executive Director of Consensus Docs, and I'm also Senior Counsel for AGC of America. And AGC is the largest general contractors organization in the country. And AGC has a history of being involved in the AIA documents. Back in 2007, as staff, I was involved with the discussions and negotiations on those documents. but it really wasn't a negotiation. AIA made it clear that it was, you know, their documents, and they obviously make the final calls on what's going to go into the documents. This time around, it was a lot different. AGC was not given even a courtesy copy of the A201 as it was being developed. And I think you're going to hear some of my comments today was it would have been helpful to get more of, I think, a contractor's perspective, and certainly a contractors association actively involved at the table in helping inform AIA on some of the practicalities of some of these updates. But AGC, what I'm going to use a lot of my commentary is consistent what's in the AGC's commentary on the AIA A201, which you can download for free. You just need to go to agc.org/contracts, and there's a link to the A201 commentary. So let's get into it. I will say this, the biggest change to the A201, the most common change, I think it's about 100 times, is that they inserted the Oxford comma into the A201, which I know from consensus docs already had that. But if you look at a red line of the documents, that actually will be your biggest change to the A201. And I'll just mention the AGC commentary was first published in July and then has actually gone through a couple of revisions based upon additional comments that I was able to incorporate in today's presentation. Now, flipping over to consensus docs comprehensively updated the Consensus Docs 200 General Conditions and Agreement document in December 2016, and then did, on 2017, the Design, Build, and Seam at Risk updates in a manner that was consistent with the General Conditions updates in the 200. Consensus Docs, if you don't know, is a coalition effort of 40 different organizations. It's been around for over 10 years now. It has a great track record of putting not just millions, but billions of dollars of construction in place using the documents. And we see very little, good news here, very little case law. In fact, no case law to date using Consensus Docs contract documents. I think I mentioned before the AIA documents, a strength and maybe a weakness of their documents is that they're heavily litigated, and there's a lot of case law interpreting those documents. There isn't case law, obviously, interpreting the new language and changes we're going to go over today, but the basis of what's fundamentally been in the AIA documents has a long track record of case law interpretation. The bad news with that is someone has to go to court and have litigation costs and fighting over that, what that language means, that there's a lot of cost for that. The Consensus Docs organization is very mindful of the transactional costs that are involved in negotiating your contracts, negotiating unfair terms in your contracts, and then having claims and litigation. The goal of the group is to lower those transactional costs to make the construction design and construction process more efficient. And so anything where you're experiencing claims and litigation is not putting value into the buildings and the projects, and therefore that's seen as a negative. So the good news is there has not been as many claims, arbitration claims, court claims, or just claims in general from anecdotal evidence and experience using the Consensus Docs documents. They are backed with the efforts of now 40 organizations, includes the circle there of the owner organizations, the more active role of the owner involvement in the construction process and making decisions on their capital projects is a point of distinguishment between the two documents. And NASFA, CURT, and COA are the three biggest owner organizations in the country. And you'll see some of that difference in perspective of a sort of a design professional-centric document versus a document that is got everyone at the table, especially the owner perspective. But certainly there's a lot of contractor organizations who are heavily invested into the Consensus Docs documents. So, switching back to keeping with Consensus Docs, I already mentioned that the updates were made in December. The three things that drove those changes, which are the things that you should be looking to update your documents, you know, my personal opinion is waiting 10 years for you to update your documents is putting your company at risk potentially because of things keep changing. Three areas that Consensus Docs noted in its updates were changes to the law. There's always cases. Updating documents is something that you need to do. The insurance market is always evolving. What you're able to procure is really important as to what you promise in your contracts. What those insurance products are called all sometimes get revised. What is eligible in Minnesota might not be eligible or easy to procure in North Dakota. It just depends on some of this stuff, and that changes over time. And what also changes over time is technology. See, a lot of things where if you're using building information modeling, if you're using websites for projects and sharing the contract documents, using documents in the cloud, these are things that do have implications on what your contracts say, and you need to reflect those, what your business practices in your contract documents. If you don't update your documents, again, you're putting your company at risk because your contract doesn't reflect your business practices. So those were the three things that drove changes in the consensus docs. There were several changes. Also, kind of like AIA, I wouldn't say that it was a radical rewrite. The general philosophy of the active owner and the fair risk allocation between the parties, the basis of a lot of the negotiations that led to consensus docs initially, I think is still in place. These were really more refinements than major revisions. So where I'm going to start is not necessarily the section numbers and not even necessarily the biggest changes that I saw in the standard documents in really the 2017 cycle. What I'm going to start with is something that I hear about all the time as being important, and that is getting paid, right? Paying and getting paid on a construction project. Sometimes general contractors like to say that it's the lifeblood of their financial solvability is to get timely payments. So here are the changes in regards to payments on the two standard documents. Consensus docs actually has sped up the application for payment from 20 days to 15 in the 200. The 200 again is the general conditions document, and that those general conditions and an agreement are in one document, as opposed to the AIA documents, which has the A201 as separate general conditions. So that also is a difference approach. And that differences keep the same as far as the different approaches from the different associations. But so consensus docs sped up the application for payment time so that timely payment, quick payment is really the lifeblood of a contractor. What else that consensus docs did, it used to have the application for payment process go through the architect. But what I had said to you before was that owners are really more involved in the construction process, not necessarily demoting architects and engineers from their traditional role of making a lot of decisions, but really it's kind of a rebalance of what at least the consensus docs organization feels like is an appropriate role for the parties, and not giving the design professional authority beyond their responsibility. So the application process used to have the architect or engineer certify payment before payment was made as an objective third party. And that is the way AIA continues to do it. The feedback we got was that didn't make sense because it really wasn't adding value. The architect isn't really a third party neutral in the payment process, and was more likely to is a sort of a paid party to the owner, and that sometimes the sense of urgency and the responsibility for processing payment wasn't there, and so that it was actually slowing payment down, having that extra layer. So consensus docs changed it, so the owner is ultimately approving the application for payment, but can direct the contractor to send it to the design professional if the owner decides that is how they're going to use the application for payment process. And again, it's a faster process. Keep in mind that changing the defaults on your contracts, such as if the payments always go through the architect or they always go through the owner, unless you change it, the defaults really do matter in what you put in standard documents, because the defaults are often going to be what the parties choose unless they make changes. The other big change on consensus docs is the way retainage is held. One of the big things that's a difference on consensus docs, that is an example of a provision you can use in your contracts, whether you use that standard document or not, is how retention is released upon 50% of the work complete. And then also what consensus docs does is when you get to substantial completion, this is standard in most standard documents, is that your retention is released. But some is withheld, and the amount that's withheld used to be 200% from the estimate to get the final completion. So a contractor doesn't walk off the site and forget about those punch list items to get this final completion. So the amount of that is withheld used to be 200%. That has been reduced to 150%. And that's true across the board of the design build and CMAT risk docs. Now let's switch to AIA. What do they do on payment terms in this round? One of the things that they changed in Article 9, and specifically in 931, is a requirement for the release of waivers, lien waivers from subcontractors and suppliers. However, the way it's written, it goes down to not just first-year subcontractors and suppliers, but it's all subcontractors and supplier of every tier with the payment application. So you need sort of affidavits that you have lien releases from all tiers. And that just simply isn't realistic when you're talking about, I guess potentially you're talking about someone who's supplying light bulbs, right? You're not going to get the Home Depot release or lien retainage at a very, very low level. And that's just going to slow payment down and cause problems. So a recommendation here is just to change, a very minor change, honestly, is just to make it so it relates this release of lien waivers only as first tier. All right, let's try to move the slides here. Also on Article 9 in the A201 is at 9.10.2 is kind of a similar type of change that AIA made, that you need to require the contractor to certify payment to all downstream subcontractors and suppliers. Again, this is something that in the AGC commentary says is not realistic to have this, and it should be restricted to just first-tier subcontractor and suppliers. Otherwise, you might never get paid. All right. WebEx kind of updated their interface here, so I'm struggling a little bit with just advancing slides here, so please bear with me. So here's a change that I don't think I originally saw the significance to, and then others pointed this out to the AGC Contract Documents Committee, who did the commentary on the A201. And it deals at 968. At first, it just seemed like a redundancy. When you have a lien claim in the A201, you are required to post essentially a bond to cover the amount that is being liened. So the contractor has to make the owner whole, and that's at 9.10.2 again. That remains, right? But now the contractor's asked to do more. You now need to clearly indemnify and pay all attorney costs at 968 for any possible liens, if there's any liens. And really what this is doing is you're really, the way this is written, it seems as though that the obligations of payment that you don't really kick into the owner, and the owner might contest that payment is due, and there might be a dispute about that. But if the owner is doing what they are obligated to under the contract, you still have to do everything to remove the lien and then defend and indemnify, including attorney's fees regarding those lien actions. So this seems redundant to the protections that the owners already had at 9.10.2, and this new language in 9.6.8 is something that I think a lot of contractors are going to ask to strike. Now, speaking of striking contents on the A201 from a contractor's point of view, this is probably the biggest reason why AGC, in regarding project financial information, why AGC did not endorse the A201 in the 207 draft. The good news here is it's gotten a little bit better in the 2017, but a little more complicated. So when we're talking about the ability for a contractor to get owner financial information, It used to be in the AIA documents that the contractor could request it and the design professional could request it, and they would receive that financial information, because timely payment, again, is very important. And if you have to wait for all the signs and all the non-payments to figure out that the owner no longer has the project financing in place, it's too late, and that you're potentially putting your business at risk, so to speak. And why would an owner want to hide that kind of information from its partner, the contractor, on the project? So in 2007, AIA, right before the Great Recession, where a lot of owners of project financing dried up, it was kind of a tsunami of the change was that the contractor, once dirt was moved, essentially, had to make a showing for financial information. And there was a lot of pushback on this. And then, like I said, the economy really, especially in the construction economy, collapsed. And so this time around, AIA has made it clear that at least the contractor has the right to stop work if the financial information is not provided. Now, but what they did do is, the way that this works with the default in, say, the 101 is, once the work starts, the project starts, you have to make a showing for the financial information. So it's not even necessarily when dirt is moved. The default now is when the contract is signed. Now, you still have the ability to request the financial information, and then it's up to the owner to decide whether they, or the architect, whether they have to give you that financial information if there's sufficient reason. But if there is sufficient reason, which I think is a big question mark, then you can stop work. But you can only stop work in the area affected by the material change giving rise to the need for the contractor's request for financial information. Seems a bit complicated to me, and I think what's going to happen is it puts the contractor in an unknowing situation of, can I stop work in that area or not? And what do you do? The consequences of being wrong in this case and stopping work is pretty significant and can be, so to speak, deadly to a contractor. So it kind of puts you in limbo, and you're more likely going to get counsel to keep work if it's unclear as to the extent of the material change of which you can stop work on. It's just to kind of create ambiguity, and you don't want to have ambiguity in your contracts. It would have been nice to have more clarity on this point. That's kind of one of the things that I would say is if there was a contract organizations really actively involved in a partnership on drafting these documents, this is something where maybe if the ears were open, that's something that could have been negotiated that was a little bit more beneficial. The other thing that the new financial information does is, I said it's more complicated. It also creates something that is another layer here, is to that it's confidential information when you request the financial information of the owner. And it's kind of a long paragraph here, and it is silent on to whether a general contractor can share it with its subcontractors, but it mentions nothing about the lender, the bank lender with the construction loan. And that seems to me a big miss on this new section and should be amended. So again, good news is you have a little bit more teeth on getting financial information, but the bad news is the ability to stop work is unclear because of the language about the extent of the material change, and who you can share this information. You should negotiate something where it's clear that you can at least share it with your lenders. Now, on the consensus doc side, it's been pretty consistent of what the language says. Now, what generally I say is, don't use the old 97 version of any standard document. Don't use the 2007. Use what's updated, unless it gets worse, right? But in this case, the old AIA language was more simple and clear, and quite frankly, that's a similar approach to what consensus docs takes in its standard language. It did in 2007, and there is not major changes to the ability to request financial information. If you ask for financial information, the owner owner needs to give it, and if that information isn't given, the contractor or constructor can stop work. It's a pretty straightforward way of doing it. The other thing that consensus docs offer, again, that you might want to use piecemeal, is how do you ask for financial information? There's actually the 290 and 290.1, which is a sample questionnaire that is endorsed by the owner organizations as a tool in the toolbox on how to request for financial information. And that's the consensus docs 290, and 290.1 is the instructions. And you can get samples of these documents by going to consensus.org, registering, and you can get 3 samples for free. And if you need more, you can just contact the group to get more. So here's a big change from AIA is in regards to claims. How they handle claims, this is one of the bigger changes, right, of the A201, is they've bifurcated asking for claims and what the kind of notice that you need to give. There's one kind of notice you give if there is a claim, and the amount of notice that you need to give is much less if it's not a claim. So for contract administration. Here's the bad news. What do you do if you give the less formal claim and you turn out to be wrong? I'm sorry, you gave the notice as though it wasn't a claim, and it turns out you needed to give notice for the claim. The bad news is your SOL, if you didn't give proper notice, you might have, that also depends a little bit on the state that you're in and some contractual interpretations, but you generally want to err on the side of being more formal on your notice so you don't lose your substantive contractual rights. And here's the thing, the definition of when you have to give the more formal notice depends on what a claim is. And here, a claim is really broad. A claim is demand or assertion by one of the parties seeking as a matter of right, payment or money, a change in contract time or other relief with respect to the terms of the contract. So, again, claim is very broad, and when you have a claim, you need to give more of the formal notice. Here's 2 things. When you're giving the formal notice, you're now going back to the green cards and return receipt. You need to do that when it's formal. But when you're giving formal notice, which you can no longer do, which is something that is pretty common on projects, that is totally silent, and you are going to lose your claim if you do what you've been doing for the last 100 years, and that's giving hand delivery for a formal claim. You can no longer do that. And here's the other thing. Certainly email is not allowed, and email is not allowed on the less formal claims unless you write that into your contract. That is not the default. The default for giving any kind of notice, email will not work, even though that is probably the most prevalent way of communications today. So write that in the contract, turn the non-default into the default that you can give notice on projects and communications through electronic means. It's not hard to do, but you do need to fill that into the agreement. The other thing that's puzzling about the claims section here is if you read it, I told you it was real broad. It's real broad, but what's not a claim if you read through this? When you read through the AIA definition of claim is liquidated damages. I think on the other side, I think a lot of contractors think of liquidated damages as a claim against them. Certainly it has real financial consequences. But again, unless you change the new language, the owner what's good for the goose is not necessarily good for the gander as far as getting notice on claims, because liquidated damages is not included in the definition of claims. Okay, how does consensus docs handle it? I mentioned that technology was a big driver of changes, and it's something that you need to reflect. And I also already told you that email is commonly used on projects. So consensus docs, and had published its documents first, also made a big change in regards to notice. They made notice more permissible, and basically email by default or any effective means is allowed to give notice on claims or non-claims. There's no distinguishment in the consensus docs documents. There is a distinguishment on certain kinds of claims you can't give email notice for, and that's when you go nuclear, as I say. And so if you're going to do nuclear, would be termination, termination for convenience or termination for cause, you need to give formal delivery. And that seems to make good sense to me when you're going nuclear to have to do something a little bit more formal. Other changes in regards to formal claims and dispute resolution and mitigation in the consensus docs documents relate to mediation. One of the changes that consensus docs makes changes every 5 years, but also makes off-cycle changes if there's changes in the law, insurance, as I've mentioned before. And dispute resolution is one of those areas that consensus docs actually has made changes a couple of times off-cycle because of changes in the law. But we didn't make changes to mediation and this off-cycle, and so now you see some of the consistency changes that we made in arbitration, now we make to mediation. And what are those? Well, now JAMS is another provider, and apparently it's being used a lot for mediation. So there's AAA, there's JAMS, and then there's self-administered mediation. Those options are now very explicit and clear in the documents. And then the default, if you don't check any of the boxes, it defaults to AAA. And like I said, the party-selected rules, which you can always, and provider. Now, you can always opt into these. The parties can decide to do mediation by their party-selected rules after the contract is signed, but it really does help to get this all clear in your documents ahead of time, so that's one less thing you're potentially fighting over. Now, arbitration has also had some changes. There was some case law in New Jersey and Maryland in regards to the enforceability of arbitration. And so consensus docs updated its language to have some magic words based upon those court cases to make them bold and in uppercase that, hey, if you're using arbitration, you're giving up your right to have a judge or jury look over your case. And the cases we're dealing with were probably residential in nature, so they were more consumer-oriented, but it was unclear whether, again, under other language, whether the party's choice to choose arbitration as opposed to litigation. It seemed like some courts, some states take a view of it that they're strictly construing what I see as the party's clear choice. And so you want to just be as clear as possible to have those magic words. So if you want arbitration as opposed to litigation, that is actually enforceable. The other thing that we did in arbitration or consensus exchange was to try to make it less expensive when you are using arbitration by opting in the fast-track procedures. So that's cases that are decided within 45 days. They are mostly paper-only exchange, so you don't have more of your process and depositions and more litigation-like procedures that have started to become more of the norm in arbitration to be less of the norm in a fast-track arbitration. So if you're using AAA, you are opted into the fast-track procedures if your claims are less than $250,000. And again, there were some minor changes to make it clear that AAA is the default provider if none of the boxes in your choices are checked. Now, I think in the AIA documents, again, if you're using a paper version of your documents that I think you can purchase, your checking no box is going to be litigation. I believe the software, and I haven't used it recently, is that there's a default to arbitration. But again, I haven't used it recently, so I don't know if that's still the case. Just choose the resolution method that you want and make sure that's going to be enforceable. Now, switching back to AIA, they made some revisions to their dispute resolution procedures. A big change in 07 was the creation of the initial decision maker. Now, according to AIA, the vast majority, I think it's 95% and higher of the time, the default of the IDM is, guess who? It's the architect, and the architect is going to be serving as the initial decision maker. They have some processes that, to me, and as mentioned in the AGC commentary, are a bit confusing in regarding to the timing of the IDM in 07, and this was tweaked in 2017, and I think it may be even more confusing, but that's just me. The IDM process basically is if the IDM makes a decision and that you want it to go final, the one party tells the other party that they have to contest the IDM's decision within, I think, 60 days, and then if they don't contest, then it's not something that they can appeal later. The process. So what do you do in that kind of situation? If you contest, you potentially lose your rights. If you do, if you do contest, you potentially save your contractual rights. So it seems to me like if you're on the fence of that, you should err on the side of caution and contest if the other party is asking you to make a IDM decision final, and you should do that within the time frames and do it quick. Another big change from my perspective in the AIA documents and the A201 is how they deal with communications. Now, you may not have realized, but in the A201 philosophy of how contractors, owners, and architects interact, you may be surprised to know that in the agreement between the owner and the general contractor, which is with the A201 is the general conditions for, it said in section 4.24 that you shall endeavor not to talk to one another directly, but only to do so through the architect. All communications shall endeavor to go through the architect. Here's the good news. Big change, that is no longer the case. So kudos to AIA for recognizing that in the 21st century, that direct party communications from the contracting parties is not something, is not necessarily a bad thing that should be avoided. Now here's the part that's a little confusing that you need to be careful of. In the new language, it kind of parses this out of whether the architect needs to be put in a loop or not. And it says, well, you have to backfill the architect on owner, general contractor communications if it does two things, one of two things. One is if it affects design basics, the architect services, or if it deals with design intent. And so my view on this is if you may have to loop in the architect for one of those two reasons, under an AIA contract, it's hard to perceive something that doesn't involve the architect services or design intent. And so that, again, to err on the side of caution, you should just probably, to not be in violation of your contract in the A201, you should probably loop in the architect or change that section because obviously a lot of communications are going on without funneling through the architect, but it doesn't seem harmful to loop the architect into the communications. In consensus docs, has consistently actually had a philosophy of having direct party communications as a way of mitigating and avoiding disputes. And it has things that are, sets the tone where we actually have some positive language in regards to having mutual trust and good faith and fair dealings. But more importantly, on the dispute mitigation side is the parties have to talk to one another within 5 days. And if they can't resolve it, they have to talk to one another at both the project level and then the senior project level within 5 days. This has been extremely effective, and something that you could steal in your contracts is this tiered direct communications, tiered mitigation dispute resolution process. Now moving back to the AIA documents on some of the more substantive provisions, another big change, and maybe the biggest change, is what AIA has done on their termination for convenience as far as the general conditions go. It used to be at the prime level, you got, if you were terminated for convenience, which in a sense is going nuclear, but it really wasn't going nuclear because you got lost profits on work not performed and all your demobilization costs. So you're basically, it's almost like common law breach of contract. You almost didn't need a termination for convenience because you're going to get all the remedies for a breach of a contract. They've changed that. They've changed it radically. And unfortunately, they've changed it inconsistently because it doesn't flow down to the subcontracts, the AIA A201 subcontract, again, unless you change the subcontract. It's a little unclear as to some of the language on the termination for convenience because it does say something about consequences of the termination for convenience that are indirectly involved in the termination for convenience, and that may relate to the cost you have with the subcontracts in a termination for convenience, but that is, I don't know if that's the intent of AIA, and I don't know if that's how it's going to be interpreted. But the main thing you know is now you have a fill-in-the-blank premium that you need to negotiate. The premium is supposed to cover demobilization cost. It's going to cover your lost profit, your anticipated lost business opportunity that you could have had if you had taken another project. It's a big deal. Now, I will tell you that my sense is I bet a lot of owners crossed out the very generous provisions regarding termination convenience in the A201. Now, what I will tell you is that those very generous provisions do remain in the A401. And again, usually the general rule of thumb is you want to flow down things consistently in your contracts. In consensus docs, it also has a fill-in-the-blank premium, but things like demob costs are, instead of just something you have to negotiate, is something that's included. Related attorney fees is something that is, again, is sort of a direct cost of the termination. You don't need to negotiate that. Because here's the thing about this, the premium that I think is a little disconcerting, is the cost for terminated for convenience on day one of a project is going to be totally different than if it was day 180, right? And of course you're going to get the money for the work performed and the profit and overhead on the work performed. But again, this is something that is very important. It's a huge change. And whatever you do, you're going to have it consistent in your contracts, I think. So definitely watch for how this flows down. In consensus docs, we made a change for, I'm going to skip to the termination for convenience. I've already mentioned this. We have the reasonable attorney's fees is added to an automatic cost that you get if you're terminated for convenience. And really, in the consensus doc 750 and 751 subcontract, we really don't have a termination for convenience. You only have the ability to terminate a subcontractor if the owner terminates. And so there's a real concern about bid shopping, and therefore this is something that in the standard language, termination for convenience at the subcontract level is not written in the documents. I will tell you that I think that is probably one of the more common modifications and additions to the standard documents for the AIA and consensus docs. You're going to see that language included in that's different than the standard. Going back to termination for cause, what I call going nuclear. The point of a termination for cause, you won't allow the owner to terminate if there is cause to do that. But what you really want on a termination clause is to give notice to fix the problem. The goal of a termination clause is not to break your contract, it's to fix the problem. And so consensus docs clarified its language. You get a first notice of 7 days, and then after that, it's giving the contractor or the constructor the opportunity to fix the problem to the likings of the owner, right, to be not in default of the contract. So there's a clear 7-day notice and then a 3-day notice if the changes were not put into place. And then there's notice that has to go to the surety as well to make sure that they're apprised of the situation. But if there is a termination for cause or convenience, no longer, there's some added language that, again, I think is pretty positive, is that the default is you can't just use the equipment that's left on site. You actually need to get permission from the contractor. If they've left a crane on site, you need their written permission to use it if they're being terminated, and you need to indemnify them for that use of equipment because they're not controlling it anymore. So that, again, I think is a positive refinement in the 2017 editions. Moving on to slide 25. Another positive change that's only in consensus docs now is how we handle, or how consensus docs handles indemnification. All the indemnification provisions, you kind of, in general, you want your indemnification and insurance coverage to match one another, but consensus docs went a step further, to be fair, is that all the indemnification provisions basically say this: if you're negligent, you have to protect the upstream party for your negligence, but they're silent as to intentional acts. So if you didn't mean to do it and it was an accident, the owner's protected. But if you meant to do it, the owner is now in trouble, right? There's no protection for self-sabotage or the rogue employee or the rogue subcontractor who intentionally does damage to the construction project like you see here. Well, that doesn't make sense. That's, you know, why would there be a difference? Why would the owner be in a worse position if it was intentional? So consensus docs changed the standard language to now include intentional acts in the indemnification. I think that's just a fairness argument. Now, switching back to AIA, here's one of the provisions, or a couple, it's in 2 sections, that gets my goat, to be honest with you, because my job is to write standard construction contracts and to make them consistent throughout. And to be fair, right? To be fair and help parties use the documents and let them modify it. AIA has done something in Section 1.7 and 1.8 that I haven't seen in any standard documents before, is that they're changing your contractual substantive rights based upon a logo appearing on a piece of paper. They reference their digital data documents and their BIM documents in these sections, and they say that if you're going to share information electronically, if you're going to use BIM and have the protocols, you have to use, not just suggest they use the AIA documents or their equivalents, but you have to use them, or that your substantive rights may be impacted. And I think from a standard contract documents perspective, that's ridiculous, because you should be allowing people flexibility. There is a consensus docs BIM addendum. There's a consensus docs electronic communications protocol. You sometimes mix and match those documents, especially since they've been industry firsts in those, and people mix and match all the time, or they create their own versions. But the way that the AIA documents are written is that it specifically says that it has to have the AIA logo, which is an eagle. I didn't use the eagle in this presentation because I certainly wouldn't want to be accused of copyright infringement from the AIA from using their logo. But you know, you have to modify the standard language to use your own BIM protocol, your own BIM addendum. And that's an easy enough change to make, but it's not the default. Another change, maybe a non-minor change to the minor changes in the work section in the A201, is at 7.4. I think it's a major change, potentially, if it hits you. It basically says that if you don't object to a minor change and you're saying that you don't have any substantive rights later to ask for more time or money if it was said to be a minor change in the work. So unless you notify the architect that you say you disagree that it's a minor change. So again, if you have a choice of giving notice saying that you disagree that it's a minor change and maintaining your substantive contractual rights, or being silent and potentially losing rights down the road, which should you choose? It's setting up a situation here where you're encouraging people to be a little, I think, antagonistic because you're putting them potentially in a bind and making the contractor have to give notice really pretty quickly that something is a minor change or isn't a minor change. And if they don't notify, they're losing their rights. And I think you're setting yourself up for certain dynamics on a project by writing your contracts with those kind of defaults. Now, here's another section on the A201 that quite frankly, at first, I thought was just a minor change, where there's a savings clause if anything that was deemed unenforceable in the contract, the rest of the contract is still enforceable. But people looking at this have told me, and I now agree, I understand the point here, is that this new 1211, it invites the court system to rewrite your contracts potentially if with the savings clause, because it doesn't ask to enforce the contract as written, but kind of encourages the judge or arbiter of your contract to rewrite the contract so to make it enforceable with the rights and obligations of the parties. And so that This is something that probably was unneeded to go that far because there's almost all courts have the rights to use equitable solutions to fix contracts and their enforceability. But this potentially is being debated. Again, the AIA has been around for 100 years, but this is new, and this provision is being seen as something that could wreak havoc and have someone who's not even a party to the contract rewrite your contract because of the way that the savings clause is rewritten. All right, moving back to everybody's favorite topic is insurance. Construction contracts, now we get construction contracts and insurance provisions. But this is one of the more significant, if not the most significant substantive change to the consensus docs updates in the most recent round, and AIA made big changes in insurance as well, is into the property insurance. The builder's risks property insurance changed the default. Now, historically and in all the other standard documents, the owner procures the builder's risk policy. However, in the feel and practicality, I'm hearing it's more than 50% of the time that the builder gets the builder's risk policy. Because why? They can do two things. They get better policies because they negotiate it all the time, and they get it at a better price. Some, now I'm not saying, you don't have to quote me on this, I've heard as much as 50% cheaper. That probably is a bit aggressive of an estimate, but again, someone who was part of our update said that they got 50% better prices. Whatever it is, it's probably better policies at better prices. So we changed the default, but left the owner the option to procure the builder's risk policy. And then whomever is responsible for procuring the builder's risk policy maintains the risk of loss. So if it did switch back to the owner then has risk of loss until substantial completion. And then we changed it, the risk of loss, at the subcontract level to maintain whomever gets it, it's going to be either the owner or the general contractor, so that instead of the subcontractor having the risk of loss, we've shifted that to the back to the general contractor. Now, what did AIA do on insurance? I told you that they didn't make huge rewrites, except for the areas of insurance. Their insurance sections at Article 11, they did not take everything out of the insurance article. They took most of it out. And one of the things that you need to realize is the A201 works for not just design bid build, but is also in their CMAT risk documents. And you could sign up for a free construction law newsletter that I run for consensus docs, and there's a great article that is appearing this month that talks about how the new exhibit in the A133 is you can't just rely on the A201 Article 11 anymore, which is really soon, and one of the reasons why we have the presentation today is that I think come October 31st, the A201 2007 is being retired, so you can't use that document for the A133, even though the A133 is not going to be updated until, I think, 2019. So you need to either save your Article 11 or modify the exhibit, that the new Exhibit A, insurance exhibit by the AIA, and reference that in your A133s. If this doesn't make sense, sign up for the newsletter or go to the website and look at the newsletter article that covers this in more detail. But here's the bottom line here is AIA really radically changed how the insurance provisions work. Most of it is in an Exhibit A, and that's actually a good structure. I commend them for separating most of it out because that affords more flexibility, and people will have been doing that already, creating their own exhibits, something that we'll let Consensus Docs look at doing. We do it in one of our subcontracts, but we don't do it in all of our documents. And I've heard some real positive things about structuring your insurance provision as an exhibit. But what the exhibit does do is it sort of assumes a best case scenario that an owner can choose many different things, some that automatically apply to their project, some that don't. You have to pick and choose, and there's a concern there that someone will want to have the absolute Cadillac best insurance program ever that may or may not be appropriate for that project, but because it was sort of a menu item to check the box, of insurance exhibits that they may make choices that are overly over-insurance for their projects. One thing that is a definite concern on the new Exhibit A, there's a lot of detail and comprehensive nature to it, which is good, is the extension of how the builder's risk policy extends to the warranty period. So it's beyond substantial completion. And that's not the way most builder's risk policy, in fact, it's not the way builder's risk policy is written. And so there's sort of a mix match that for your coverage and the completed operations and how it's written, you're going to need an assortment of policies to get past or get through the warranty period, which defaults to being a year, but if you modify your contract, some people modify it even longer than that. You need to be real careful about the length of required coverage for your builder's risk policy. There's some other things in there that are a little bit of concern. One of them is that it allows the owner to settle without the builder's consent, and can easily kind of create a payment due by settling with the subcontractor on potential claims. That is something that we're going to be monitoring to see how that plays out, but that is a pretty significant change in the insurance exhibit. Switching to consensus docs, something that is not covered in the other insurance standard documents is something dealing with horizontal versus vertical exhaustion. And this is something that's really huge, and so I've taken an opportunity to share a picture of my daughter, Lila, who here is horizontally exhausted after a long day of being a princess and being real cute. And I use this as an opportunity as we're getting close to the end to sort of bring something real and a little lighthearted for something that's really serious, is that 9 states have, in my opinion, sort of negated the intent of your additional insured coverage, because most subcontractors use a combination of both primary and excess coverage to meet their additional insured obligations. And this legal theory and policy protection in your insurance policies, 9 states say, well, if it's the horizontal exhaustion theory, is that your excess coverage is not triggered until everybody's coverage upstream is exhausted. So the owner's primary and excess policy has to be exhausted. Then the general contractor's primary and excess coverage, additional insured, has to be exhausted before the subcontractor's excess coverage kicks in. And that is not the intent of what people negotiate in the additional insured protection. And so you should change it in your contracts, and that's what we did in consensus docs to indicate that there was the parties intended to use vertical exhaustion theory, which is the majority. But again, there's 9 states that have this minority provision. You also have to be real careful. What we can change is to what's in your insurance policy. So be careful about what language is in your policies regarding horizontal exhaustion. You want vertical exhaustion. And now for something different is dealing with how we updated our language with directed changes. We used to have interim directive changes, which was in AIA parlance was a construction change directive. In consensus docs language, you might want to steal this in your contracts, is that if the owner and contractor can't agree on the change order, under AIA, the contractor is essentially paying for 100% of the change, and that can be used as really very strong leverage against him or her. In consensus docs, there's a split the baby type of approach in regards to changes where 50% of the payment is due to the builder, and that the owner does not lose their right to get to recoup that 50% that they pay. But again, for timely payment, 50% of the payment is made, and then through the claims process, one party is going to get either some of their money back. If it's 50%, then that's exactly how it was split up evenly. But if the owner was 100% right, they will get the 50% money back. But again, that takes time to figure that out in a claims process. We've updated our language. Now let's just call it an interim change. One of the biggest feedbacks I get in our contracts is that they should be shorter. So by using that, we have a shorter terminology. But the other thing we do is that it now covers broader, in that it used to be just things that impacted time and money. Now they also include things like written instructions. So when there's a differing site condition and how you should move forward, the owner has to issue an interim change to give direction to the contractor of what they should do when they encounter a differing site condition. All right. Real quick here, just hit on a couple points, is on the consensus docs owner architect agreements, the 240 long form or 245 short form. There is some concern that there was a fiduciary duty created in the 2007 edition of our documents. In 2011, we took out language regarding that the design professional covenants, with the owner, and this time we got rid of any language that could be conceived of contractually created a fiduciary duty. That wasn't our intent, and now all of that language, if anybody tells you that Consensus Docs has a contractually created fiduciary duty, they're not using the most updated Consensus Docs contracts. You don't want to create a fiduciary duty in your contracts, be it a architect or design builder. In the 240, this is not a change, but I would just highlight a big difference between Consensus Docs is that in the 240s it says the services design professional, when they get to construction document phase, will provide all necessary information to bid and build the project. And that's real important, and that's a big difference than what's in the AIA documents, so the owner knows that they have design documents that will work to bid and build, or that they will be redone at the architect's expense to make sure that they meet the standard of care. Doesn't raise the standard of care, just means that they have to do the rework. Another change in general conditions on the other documents, not with dealing with cost of the work as opposed to lump sum, which was what we've mostly focused on. A change that was made by Consensus Docs is now if you have non-negligent correction of the work, then that is something that can potentially be a cost of the work. So in other words, if you're trying something where it wasn't your fault, but you were trying something, you all agree that you're going to try something new and innovative, and it doesn't work and you have to fix it, that is something that you do get recoupment as a cost of the work for. There's a lot more changes in both the AIA and Consensus Docs. Both AIA and Consensus Docs publish red lines that you can easily access on the website of the respective versions. You can email me for the Consensus Docs red line, or you can get in touch with me. We have a platform where you use Microsoft Word to make changes to your documents, and you can create a favorite from the changes in your new template from those. AIA has a cloud-based system that they recently rolled out called, I think, ACD5. I think I have ACD there, but it's ACD5. And that's another big thing. Again, the A201 is going to be grandfathered, has been grandfathered to 07, but October 31st, that grandfather is ending. And you will see soon from Consensus Docs a lean addendum and a design assist addendum as new standard documents that will be tools in your toolbox. So I'm out of time. I'm here for questions and would love to